Hello again, my government students. Today we're going to talk about the judicial branch, the United States court system. There is a page of notes that goes along with this, so make sure that you've got that. Grab that off of Google Classroom as well, from where the same place you got this video. Slides are also posted there, so make sure you grab those as well and just have those available to you if you need to. Pause the video anytime so that you can make sure you get your notes filled in, and away we go. So, a few questions to start off with. What is the highest court in the land? We've talked about this before. You should know the answer to that one. What does jurisdiction mean? It's another one that we've talked about. What article in the Constitution sets up the judicial branch? How many Supreme Court justices are there currently? What is a term for a Supreme Court justice? That means how long do they serve for? Who nominates justices and who confirms them? All of these questions we will answer today. Your objective is to be able to analyze the roles and responsibilities of the judicial branch by explaining the structure of the U.S. court system. All right, so lofty goals for us today. Here we go. Start off with this quote by Alexander Hamilton in Federalist Number 22. Laws are a dead letter without courts to expound and define their true meaning and operation. That with in there, actually, I need to edit that out of there. That's not right. So laws are a dead letter without courts to expound and define their true meaning and operation. So what does that basically mean? It means that without courts to explain to us what the laws are, what do they mean, how do they work, how are they applied, then the laws are open to interpretation by anyone. So what is he arguing a need for in Federalist 22? Article 3, the national judiciary. And the framers created the national judiciary in the first sentence of Article 3. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. Okay, so the framers created the national judiciary, like I said, in Article 3 of the Constitution. There are two court systems in the United States. There's the national judiciary that spans the country. Then there are the courts run by each of the 50 states. So there's the national judiciary, that's one. The second is the state judiciaries. The Constitution created the Supreme Court, but then left Congress to establish what are the inferior courts or lower federal courts. There's basically two types of federal courts. There's constitutional courts and special courts. So constitutional courts have to do directly with conflicts and arguments towards rights and protections of the Constitution. Special courts are used for a variety of other things, such as bankruptcy. So here's an image of the structure. Okay, so we have the Supreme Court's up there at the top. Then we have the inferior courts. We have the constitutional courts. There are 94 district courts across the United States. So 94 federal courthouses across the United States. There are 12 U.S. courts of appeals. Okay, so that means if in one of the 94 district courts, if you didn't like your ruling there, felt that there was a problem with it, you can go to the appeals court. You can appeal to have the case looked at again. There are U.S. Court of Appeals of the Federal Circuit. Then there's the U.S. Court of International Trade. Then the special courts that we have are U.S. Court of Federal Claims, territorial courts, courts of the District of Columbia, U.S. tax courts, U.S. Court of Appeals for the Armed Forces. The military has their own. And the U.S. Court of Appeals for Veterans Claims. So a whole other court just for veterans in the military. All right, so what is jurisdiction? We've talked a little bit about this before. Jurisdiction is the authority of a court to hear, which means to try and to decide a case. Okay, so when a court has a case, okay, it goes to trial. It means to try. okay, to try the case and then to decide it. That's jurisdiction. Article 3, Section 2 of the Constitution provides that federal courts may hear a case because either, number one, the subject matter. So, what is the case about? Usually that means it has to do with the Constitution or something directly having to do with federal laws. Okay, so the application or interpretation of any federal law and or the Constitution. Any matters pertaining to the sea. Okay, so any offenses or laws that were broken while on the ocean. Then number two, the parties that are involved. Okay, so who is involved in the case? Who are the people? So it could be a United States official or agency or department. Could be foreign officials. Could be two states or citizens from two different states that have issues with each other. It could be an American citizen suing a foreign government or official. Could be the citizen of one state against the federal government. Okay. So what kinds of cases can they hear? Cases where the law is at issue is a federal law. Any case involving treaties, the Constitution, the U.S. government in general. So if somebody's trying to sue the U.S. Government, that's what the word litigation refers to. Litigation refers to lawsuits. The Supreme Court may also hear cases on original jurisdiction. Okay, if the parties involved include, again, a U.S. official or agency, foreign officials, again, state versus state or citizens from different states, citizens suing foreign government, okay, or a citizen of one state. Okay, so original jurisdiction means that they're the first to hear or to try the case. Other than that, the majority of the power that the Supreme Court has is appellate jurisdiction. So that means that a case has come up from one of the lower federal, excuse me, got yawns all of a sudden. So when a case comes up from a lower federal court to the Supreme Court on appeal, okay, that's appellate jurisdiction. Original jurisdiction has to fall under one of these. Okay, so does the federal court hear this case? So here we have California suing Nevada to gain access to a river that flows along the border. Yes, that's state versus state, so the federal courts would hear that. Your neighbor is caught stealing your mail out of your mailbox. Yes, it's a federal law. Stealing someone's mail is federal law. Why is that a federal law? Because mail is controlled and maintained by the federal government. United States Postal Service, USPS, people driving around in those cool little white Jeeps with the stripes on them. The post office, that's a federal agency, so it's a federal law to tamper with somebody's mail. A teacher being accused of forging documents when applying for a teaching credential. No, that's a state law, not a federal one. Federal courts don't hear that. An employee of the CIA is accused of disclosing secret information to a foreign nation. Yes, he's a government official. Also, that's treason. That's an original jurisdiction reason for the Supreme Court as well, or the federal courts. Not Supreme Court, federal courts. Okay, so exclusive or concurrent jurisdiction. Some cases can only be heard in federal courts. In that case, federal courts have what are called exclusive jurisdiction. So, excuse me, this is having to do with federal crimes, patents, any foreign officials, things like that. A lot of cases may be tried in a federal court or a state court. So the federal court or state courts have concurrent jurisdiction. So sometimes if it's a federal crime, a state court can try it. It's kind of all depending on the circumstances, things like that. I can't give you all the details on it. Original and appellate jurisdiction. So a court in which a case is first heard is said to have original jurisdiction. A court that hears a case on appeal from a lower court has appellate jurisdiction over that case. So the Supreme Court is the only court that exercises both appellate and original jurisdiction. It can also be exclusive and concurrent. Okay, so what type of jurisdiction is it? Here's some other scenarios. When either a state or a federal court can hear a case, that's concurrent. When a case is heard for the first time, that's original jurisdiction. Only a federal court can hear a case, that's exclusive jurisdiction. If a court hears a case not on original jurisdiction, then that's appellate. Pretty simple, pretty straightforward. How do judges get appointed, or how do you become a federal judge? Well, you're appointed by the president, according to Article 2, as well as some lines in Article 3. The president nominates Supreme Court justices and all other federal court judges, who are then subject to approval of the Senate. Most federal judges are drawn from the ranks of leading attorneys, legal scholars, so it could be a professor, law school professor, could be former members of Congress, could be from the state courts. The interesting thing is there's no qualifications in the Constitution for who can and cannot become a justice of the Supreme Court. No qualifications at all. So they just have to be approved by the Senate. So the Senate does have some informal qualifications that they look for. Other than that, that's it. Judges are appointed to the constitutional courts, including the Supreme Court. They're appointed for life. That means until they die or they are otherwise removed. They can be removed through impeachment. Okay? So 13 federal judges have been impeached, and of them, 7 of those 13 were convicted and therefore removed from office. So just like with the president, okay, we've had 4 presidents now, 3 presidents who have been impeached, and none of them have ever been removed. Okay, so none were ever convicted. But 13 federal judges have been impeached. 7 of them were convicted and removed. Judges who sit in special courts are appointed for terms varying from 4 to 15 years. Congress determines the salaries for judges. Currently, at least as of 2016, the salary for a Supreme Court justice is $208,000 a year. Pretty good chunk of change. The courts of appeals were created in 1891 to handle a lot of the burden from the Supreme Court. There's 179 circuit judges that sit in the 12 appeals courts. Okay? A Supreme Court justice is also assigned to each of those, so they're kind of like the head, they're over each of those. Appellate court jurisdiction, the courts of appeals only have appellate jurisdiction. It's all that they can do. They hear cases on appeals from lower federal and sometimes state courts. So here they are. Here are the 12 courts. Geographically placed. All right, so federal judicial districts. There are 94 federal judicial districts, including at least 1 district in each state, plus the District of Columbia and 1 in Puerto Rico, because Puerto Rico is big enough to have its own. So we have this breakout over here showing you that here in California, in Los Angeles County, there is the Western Division Federal Court. There is, and that's on Roybal Street, the Roybal Federal Building. Then on Spring Street, there's another courthouse on the Western Division. In Orange County, there's the Santa Ana. The Santa Ana Courthouse is the Southern Division of the Federal Court. And then in Riverside County, There's the Eastern Division. So there are a total of 4 federal courts in California. They're all in Southern California in the greater Los Angeles, Orange County, Riverside area. So larger, more populous states are divided into 2 or more districts. So we have the Western and the Southern District because there's a larger amount of judicial work done there. All right, so district courts have original jurisdiction over most cases that are heard in federal courts. The district courts hear a wide range of criminal cases and civil cases. A criminal case in the federal courts is one in which a defendant is tried for committing some action that Congress declared by law to be a federal crime. A federal civil case is one which involves no criminal matter. So that might be a lawsuit or argument over a contract or something like that. Okay. So here again is another image with the breakdown. You have the Supreme Court at the top, the appellate courts just below. Then you have the trial courts, those are the district courts. And then below that, you have military courts, you have the Court of Veterans Appeals, U.S. tax courts. These are the special courts. All right, so interesting drawing here. This is a political cartoon talking about how the Supreme Court was a little bit leaning to the right a few years ago. Now it's very much leaning to the right with the 3 appointments by President Trump. So at that time, you had 5 right-wing leaning justices and 4 left-leaning justices. Up until the death of Ruth Bader Ginsburg, it was actually the other way around. It was 5 left and 4 to the right. Now it's 6 to the right, 3 to the left. So, but it's still, most of the cases that have been tried recently have come out with, when there was a decision, have still come out with either a 5-4 split or a 6-3 split. And the 6-3 split actually doesn't go down the party line or the political line. It's been pretty interesting, actually. So even the 3 justices that President Trump has appointed over his 4 years, who were thought to be extremely right-leaning, have leaned a little left. They've joined with the left-leaning justices on a few cases that have been recently heard. So interesting. I can answer those questions. All right. So how are federal cases appealed? This little kind of graphic organizer here kind of shows that. All right, so the kind of purple ones, reddish purple, are other courts. You've got the regular purple are special courts. The green are the constitutional courts. Okay, so in any of these that are, use my mouse here, and I think you can see this. Okay, so here in these courts, if a case is heard in any of these lower courts, and then someone decides that they want to have another court look at it, it has to go up to the next level. Okay, and then from these, then it goes up to the Supreme Court. Okay, so if you still don't like what was decided at this middle level here, you can apply to have the Supreme Court hear your case. All right, again, the Supreme Court has both original and appellate jurisdiction. Original jurisdiction over any cases involving 2 or more states, and all cases brought against ambassadors or other public ministers, basically officers and employees of the government. Most cases heard by the court are appeals cases, grand majority of them, but the court hears only 1 to 2 cases in which it has original jurisdiction per year. So dozens of cases are sent to the Supreme Court every year. Every year, the Supreme Court has to sift through those and decide which of those cases they're going to go ahead and listen to that year. And so they prioritize them by, what's going on, basically. So if it's a case where something is really very importantly pending, they might hear it right away. Otherwise, they might let it sit for a year or 2. For a case to be heard by the court, the 4 of the 9 justices have to agree that it should be placed on the court's docket. That's their calendar, basically. The way in which most cases reach the court is through the writ of certiorari. Yeah, that's a weird word. Certiorari. It's Latin. It just means it's an order to a lower court to send a record in a given case for its review. So the Supreme Court issues a writ of certiorari to a lower court to basically say, hey, we know you just tried this case. We want your information. Bring us, send us that case. Then there's a certificate. Cases can reach the court by certificate. When a lower court asks for the Supreme Court to certify an answer, that's asking them to certify, give us, certify their response. Okay. Okay, so here are the different steps. So step 1, case is filed in a federal district court. Okay, the trial happens, verdict is given. Okay, then we go to step 2. The case is appealed. They decide that they don't like the decision for whatever reason. Felt like one or a few of the witnesses were being repressed or weren't allowed to speak. Some other problem with the whole process of due process. Then you apply for appeal. The federal appeals court hears the case. Okay. And then they decide that, they decide the outcome there, okay? If the case then gets appealed to the Supreme Court, the court can either allow the lower court ruling to stand, or they can send the case back to the lower court and tell the lower court, hey, you need to make this decision. You need to look at it again. There's some things that you missed. Or they can agree to hear the case, which means then we jump over to step 4. Goes on to the docket. The Supreme Court justices hear the case, and then they make the decision. Okay, how does it work? There are the oral arguments. This is once the Supreme Court accepts the case, it sets a date on which the lawyers for both sides, they've got to show up and present their arguments there. Oral arguments, that means spoken. So they get a chance to defend their side of the case in front of the 9 justices of the Supreme Court. So basically make their argument. At that time, the court will also ask them questions. So the justices might stop them and interrupt them and ask them to clarify something. There are briefs. These are kind of the written arguments, okay, that are filed with the court. So when a court decides to put a case on its docket, it will ask the lawyers from both sides for their briefs. So it's just a written document, kind of like a short essay to describe what's going on and what your argument is. Okay, then there's the court in conference. That's where the Chief Justice presides over a closed-door conference in which the justices then present their views on the case at hand. Okay, so this part is not open to the public. Everything else is open to the public. The court in conference, this is after they've heard the oral arguments, they've asked their questions, they've read the briefs, then the justices go into a meeting in closed door and they discuss and present their views on that case, and then we'll vote. Okay, so the opinions of the courts. You have the majority opinion. That's obvious. That's, the majority of the justices voted one way. That's the majority opinion. So formally called the opinion of the court. It announces the court's decision in a case and explains the reasoning in which it's based in. So it gives all the precedent and the background and all that kind of stuff. It's usually a very long written out document. What is a precedent? A lot of the opinions stand on precedent. Precedent is an example to be followed in another case. So it's usually previous rulings in similar cases, things like that are the precedents that are set. Okay. Then you have the concurring opinion. So another one of the justices can write a concurring opinion. That means they might want to emphasize a particular point or a point that wasn't made in the majority opinion. So after the majority opinion comes out and say one of the justices reads the majority opinion, they're like, but you missed out on this one point right here that we felt we really should emphasize. They can ask permission from the Chief Justice to write a concurring opinion. Okay. Then there's the dissenting opinion. So that's The justices who did not agree with the court, one of those justices will be appointed or will be given the opportunity to write in a dissenting opinion. So they'll basically talk about in there why they do not agree with the court's majority opinion and what the precedents are that they base their opinion on. Okay, so when you're a judge, especially at the level of the Supreme Court, you can't just make a decision and go, because I like that. You have to give your opinion, but then you've got to back up the opinion with law, with precedents. There's got to be rhyme and reason to why you make the decision that you made. And then you have the opportunity to the public to explain your rhyme and reason for why you decided what you decided. Okay, so a couple of judicial philosophies. There's basically two. There's judicial restraint and judicial activism. So judicial restraint says that judges should always try to decide cases on the basis of either original intent of those who wrote the Constitution or enacted the law or statute. Okay, so what is the original intent of them? Or precedent. Okay, so there's two things. Original intent or precedent. Precedent is, goes along with the previous decisions. Okay. This was really decided within the Rehnquist court. And there's Judge Rehnquist. Courts are named by who their Supreme Court justice was. Okay. So the Warren Court, Chief Justice Warren there, this is the first time we saw judicial activism being used. So this is where judges should act more boldly. The law should be interpreted and applied in the light of ongoing changes in conditions and values. So just to give you an idea, the Warren Court was the court that decided Plessy versus Ferguson. Sorry, not Plessy versus Ferguson. Overturned Plessy versus Ferguson, desegregating. I can't think of it right now. Brown versus Board of Education. There you go. They decided on Brown versus Board of Education, desegregating schools. So that was judicial activism. Had original intent been used, they probably would have stuck with the way things were going, because precedent said that segregation was okay, Plessy versus Ferguson. So activism goes against sometimes original intent and precedent, all depending on what the signs of the times are. Actually, I didn't take the time to update this. I should have updated this. This is actually pretty old. So pardon me for that, because Anthony Kennedy is now off the court, and Antonin Scalia died, and Ruth Bader Ginsburg died. And so those are the three replacement people there. Sorry, I didn't update that. I will update it when I post the PowerPoint to Google Classroom. Another political cartoon, okay. I'm not really going to go over these too much, and I'm going to actually, let's go into state courts, okay. Kinds of law applied in state courts: constitutional law, laws based on the Constitution; statutory laws by the state government; administrative laws, those are composed of rules, orders, regulations by federal, state, or local executive officers, so mayors. Common law, based on judge-made rulings dependent upon accepted ideas of right and wrong and fairness. Equity is preventative laws based on fairness, justice, and right. Criminal law defines public wrongs and provides for their punishment. Two levels: there's felonies and misdemeanors. Civil law relates to disputes between private parties or private parties in the government that are not covered by criminal law. These cases are referred to as lawsuits, okay, or litigations. They lead to an award of money usually, or a fine. We talked a little bit about grand juries. Grand jury determines whether the evidence against a person is sufficient to justify a trial. consists of 6 to 23 persons, depending on the state. A majority is needed to come up with an indictment. Okay, indictment is basically a statement saying that there is enough evidence to justify a trial. And they meet in secret. It's not a public situation because the evidence that's presented is going to be the same evidence that's presented in the case if there is a trial. There's a petite jury. The petite jury hears the evidence in a case and decides the disputed facts. That's the jury that most of you are going to be more associated to and with. So when you get jury duty, it's for the petite jury. That's usually a number of 12. The verdict must be either unanimous or by a large majority, depending on the state. Most of them are unanimous. There are 58 superior courts in California. That's one in each jurisdiction. They have jurisdiction over both criminal and civil cases. There are family courts, juvenile courts, probate courts. That's when somebody dies in their property and nobody knows what to do with. Small claims courts and traffic courts. California does have 6 intermediate or appellate courts. On the California Supreme Court, that's the highest court in the state of California. There are 7 justices, and the governor appoints those justices onto that panel. Okay, judicial review. This is another idea here. Judicial review refers to the power of a court to determine the constitutionality of a government action. The Supreme Court in 1803, Marbury versus Madison, first asserted its power of judicial review in that case. All right, so how does the structure of the U.S. court system ensure both justice and fairness? I believe that is on your notes there, so answer that question. And that is it. It's kind of a long one, but it's over. And thank you very much for attending, and we'll see you later.